Hello, you're watching Addleshaw Goddard's Employment Channel on the 14th of July 2011. In today's programme, we look at a recent Supreme Court decision about whether a public sector employee can bring a lawyer to a disciplinary hearing. We'll also touch on an Employment Appeal Tribunal decision concerning an employee who was dismissed for refusing to take a pay cut. And finally, we report on the Advocate General's opinion regarding carrying over holiday and holiday pay during long-term sick leave. You may recall the controversial Court of Appeal decision last year, which ruled that an employee of a public body should be given the right to legal representation at a disciplinary meeting, where the outcome of the hearing could have a serious detrimental impact on the employee's career and future career prospects. Whilst the right did not in itself apply to private sector employees, there was some nervousness at the time that this would lead to creep, and we would see more private sector employers accepting requests by employees to have lawyers present at disciplinary meetings. This was the case of R on the application of G and governors of school. In an interesting turn of events, the Supreme Court has recently overturned the Court of Appeal decision, and in doing so considered when an employer's refusal to allow a public sector employee to be legally represented at a disciplinary hearing is in breach of Article 6. As background, Article 6 is of the European Convention of Human Rights, and it concerns the right to a fair trial. It provides that, amongst other things, everybody is entitled to a fair and public hearing in relation to the determination of civil rights. And in this case, the relevant civil right was the continuation of the claimant's profession. The Human Rights Act enforces the Convention rights here in the UK. In this case, the Supreme Court agreed with the Court of Appeal that Article 6 may apply in certain situations where the outcome of a disciplinary could profoundly damage an employee's career. However, it felt that on the facts, although the employee faced dismissal from the school, this didn't necessarily mean that his long-term career would be profoundly affected. And so Article 6 was not triggered, and the employee couldn't rely on the right to a fair trial to insist on legal representation at the disciplinary. The added complexity in this case, which made the decision all the more difficult, was the fact that the school was obliged to notify the independent safeguarding authority, as it had dismissed the employee on the basis that he was unsuitable to work with children. The ISA then had the power to put an individual on the children's barred list, and in this case, if the employee was put on the children's barred list, his right to practice his profession as a teaching assistant going forward and to work with children generally would have been severely impacted. And so the Supreme Court needed to look at the extent that the ISA would have been influenced by the outcome of the school's disciplinary meeting to determine whether Article 6 was triggered at the disciplinary stage. Victoria Bell comments on the facts of this case in more detail and what the decision means for employers.
The facts of this case are fairly specific. Here, the claimant, a teaching assistant at a primary school, was dismissed for having an inappropriate relationship with a 15-year-old boy. He requested to have a lawyer present at his disciplinary meeting, but the school refused this request. He then issued judicial review proceedings and argued that this infringed his Article 6 right to a fair trial. The High Court agreed with him and said he should have been given the right to be legally represented. It ordered a differently constituted school disciplinary committee to rehear the case. The school appealed, but the Court of Appeal dismissed the appeal. In doing so, it noted that Article 6 applies to the claimant's right to a profession. Although this matter was to be determined by the independent safeguarding authority, given the substantial influence or effect the outcome of the school's disciplinary hearing would have on the ICA's decision, it was right for Article 6 to apply to the school's disciplinary meeting. The school appealed again to the Supreme Court, and the Supreme Court overturned the Court of Appeal's decision. The majority held that the school's disciplinary proceedings wouldn't have a substantial influence or impact on the proceedings before the ISA. The argument being that the ISA wouldn't be influenced profoundly or at all by the school's decision. The ISA was duty-bound to exercise its judgment independently and make its own finding of facts before placing someone on the barred list. Consequently, the claimant wasn't entitled to legal representation at the school's disciplinary hearing. Public sector employers will welcome this decision. Previously, following the Court of Appeal's decision, there was some confusion about whether an employee could bring a lawyer to a disciplinary hearing held by a public sector employer. It now appears that the threshold is higher than at first thought, and so it's likely that, in the vast majority of cases, the right to legal representation will not be triggered, unless, of course, this is provided for under a contract or disciplinary procedure. That's not to say that employees will no longer make such a request, but public sector employers will now have stronger grounds for refusing the request and simply reminding employees that their right to representation is limited to a colleague or trade union representative. It's also a reassuring decision for employers and practitioners alike, as having a lawyer present at such meetings inevitably runs the risk of making the process more formal, expensive and time-consuming than is necessary.
Thanks, Victoria. Moving on now, the Employment Appeal Tribunal decision in Garside and Laycock Limited and Booth is an interesting development, as it gives guidance on an issue that our solicitors advise on a fairly regular basis. It's also topical as, given the current financial climate, employers are being forced to explore different ways to avoid redundancies, and requesting that employees take a pay cut is one of them. So, in this case, to avoid redundancies, Garside and Laycock Limited asked its workforce to take a 5% pay cut. Mr Booth refused and was subsequently dismissed. He brought a claim for unfair dismissal and won his case at the tribunal. At appeal, the EAT held that the tribunal was wrong to focus on the reasonableness of the employee's refusal, and in certain circumstances it may be fair to dismiss an employee who refuses to accept a pay cut. This would fall under the some other substantial reason for dismissal category, which includes business reorganisations and changes to terms and conditions. It's said that an employer must act reasonably when dismissing someone for refusing to accept a pay cut, the size and resources of an employer being a relevant factor to consider, but also the dismissal must be in accordance with equity, and relevant factors being, for example, whether the pay cut affected managers as well, how the process had been negotiated, whether the majority of the workforce accepted the pay cuts, and, for example, the extent to which the employer was in financial dire straits. This is a helpful decision for employers considering imposing pay cuts. It indicates that the reasonableness of the employee's refusal to accept the change is not the most important factor to take into account. The employer's reasonableness will also be under scrutiny, and there are a number of factors that an employer can rely on to justify a dismissal on these grounds. And finally, an interesting development clarifying a much debated area in the field of holidays and holiday pay during long-term sick leave. The Advocate General has handed down her opinion in the German case KHS AG and Schult. She said that under EU law, workers on long-term sick leave do not continue to carry over the right to paid annual leave or to payments in lieu of their holiday entitlement for an unlimited period. She commented that a carryover period of 6 months would be insufficient. Rather, an 18-month minimum carryover period would be more appropriate, and Member States should use this as a guideline to follow as far as possible. So we'll have to wait to see for the ECJ's decision in the Schult case, which may take a few months. But if the Advocate General's opinion is followed, and they generally are, this will be good news for employers. In the meantime, however, the opinion is nevertheless a helpful source to refer to if you are dealing with this type of issue. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.